Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. We are going to discuss a case regarding Posco Act, whether the police are required to register the Posco Act case immediately or not. That is, whether they can conduct some preliminary inquiry or not, as stated in Lalit Kumari case. Bombay High Court, single judge, two judges bench, Revati Mohite Dore, that is Maharashtra name, and Sharmila Deshmukh. While hearing a petition, actually this writ petition is challenging the circular of the Commissioner of Police Bombay, Bharat Bombay or Bombay City, which stated that if the police wants to register a case under any provisions of section 4, section 8 like that of the Prevention of Children from Sexual Offences Act, in simple Posco Act 2012, permission of the Deputy Commissioner of Police is necessary. That is to say, Posco Act cases are being misused against the innocent persons. That is the opinion, right? So the very ill-famous, once again I have to say, Sanjay Pandey, the ex-commissioner of Bombay, at the time, I think he has retired, he is arrested by CBI or something, ED. So during his tenure, he has given instructions that without permission of the DCP, you can't arrest, you can't register a case. So this circular was challenged by some person, right? So here, they have actually in this connection, they have come across or they have discussed so many case laws also. Here the important point is the petitioner is challenging the circular issued by Mumbai CP. The circular stipulates that the permission of the DCP has to be taken before the registering the FIR under Posco Act, as well as the outraging of the modesty woman. Modesty, right from 354, 354A, 354B, 354C and stacking 354D of the Indian Penal Code. Right. So the allegation by this man is that he wanted to report the sexual harassment on his wife and daughter by some accused person, because I cannot tell the names. I should not tell the names, right? So, but the police refused to register the case, saying that there is a circular, they wanted to conduct preliminary inquiry. Agreed by this, he has approached the court. This is the story. So when the matter came up before the two judges bench, I think the Advocate General clearly stated that the circular has been withdrawn by the new CP, Kadam or somebody, on 12th July this year, 12/7/2022. The circular was issued in 2016. Yeah. And now it has been withdrawn. Anyway, that circular is not there. Okay, to some extent it's okay. Here, the point is, since the police did not reach the case, this man has filed a private complaint before the JFCM under section 156 clause 3 CRPC, and that has been registered. Of course, the investigation will take place and things will roll on. But the point is whether police are competent to issue a circular or not, number one. Number two, whether police can make preliminary inquiry before registering the case. This is important. Friends, here, please remember the celebrated case, landmark judgment, Lalit Kumari versus Government of UP and others. The judgment came in the year 2014. There, it was discussed threadbare. Actually, Lalit Kumari was the daughter of Bhola Kumar and she was kidnapped. Literally, she was kidnapped. Then this man went to the police station. They did not register the matter. In that connection, he approached the Honorable Supreme Court of India, and there, Honorable Supreme Court of India has given certain directions in which the police have to register the cases regarding cognizable offences under section 154 CRPC. There is no doubt, you don't have any doubt. But there are certain instances where preliminary inquiry can be conducted. That preliminary inquiry also should not exceed 7 days. I think 4 or 5 are there. So number one, matrimonial disputes. in a Hindu family. We don't want to divide them. We want to unite them. Therefore, matrimonial disputes, some counseling may be necessary, some type of preliminary inquiry may be necessary. Therefore, yes, absolutely, you can conduct the preliminary inquiry in matrimonial disputes. Then, commercial cases, where lakh crores of rupees are involved, it's not easy to adjust the case, to investigate the case. Therefore, whether there is any material, whether it is a breach of contract, whether there is civil matter is involved, like that, they have to conduct preliminary inquiry. Then, medical negligence cases. You all know Jacob Matthew versus State of Punjab. In this case, it is very clearly stated that the police officer should not automatically register the case. He has to consult a senior surgeon about the particular deficiency, and if he is satisfied that there is a negligence, medical negligence on the part of the doctor, then only he has to register case. Of course, it is clearly visible, then he directly, suppose if a doctor forgets the scissors and put it in the abdomen while conducting the operation, if it is traced in the X-ray report, then there is no necessity for the so-called expert opinion. Likewise, this is if there is abnormal delay, if there is abnormal delay also, we can conduct inquiry. And SC/ST, of course, it is overruled by amendment of the state. So, in these cases only, the police can conduct, well, that too, please remember, it's only 7 days. That's all. So, here, this is a Posco Act case. So, therefore, the Honorable Court stated that, right or wrong, when such incident is noticed, definitely police, they are supposed to, they have to register a case, they have to register an FIR. So, this is the direction. So, normally, the court placed reliance on another case also, that is Shyam Sundar R. Agarwal versus State of Maharashtra 2007. And Bhola Kumar, of course, our Lalit Kumari case is Bhola Kumar's daughter. That case is also there. We have discussed these two cases. So, finally, to conclude, I want to tell you that it is the onerous duty, it is the statutory liability of the police to register a case, particularly a cognizable case under section 154 CRPC. Whether it is a Posco case, whether it is a dowry harassment, whatever it is, if you register a case, he is not bothered, because investigation, it will be in his hands. Yes, if he thinks that is a false case, he can right royally refuse it under section 173 CRPC. There is no need of waiting for 1 week. But of course, in the cases as stated by the Supreme Court, like commercial transactions, like matrimonial disputes, or where there is a delay or latches, yes, they can take their own time. I think by now you might have understood the essence of section 154 CRPC, or the registering of cases, compulsory registering case upon registering of cases. If you know this much, it is efficient. Thank you.